Hi. Since I heard my name first, I thought I would introduce myself. I'm Sharon Zachariah. I work with a lot of startups and scale-ups, and as well as medium-sized businesses who are quite established on their commercial contracts negotiations, setting up their documents and processes that comply with their contracts so that they get a really solid start in business. I was an in-house lawyer for about 11 years, a private practice lawyer heading departments in London for 4 years, and now I have my own business called Innovation Law.
Hi, Anton, my fellow esteemed panelists, and everyone listening to us on this podcast. Happy New Year to all. I'm Ishita Luthra, founder and lawyer at Lex One Consulting. We help startups and businesses with their legal needs, from setting up to preparing constitution documents, business contracts, brand registrations, website T's and C's, investment documents, and loan arrangements, etc. I've also written a book called The Inner Circuit, which is a book that explores how mindfulness in yoga and breath work can help us deal with the complexities of modern life. I'm again happy to be here and answer your questions today. Thank you.
Hi there, everyone. My name's Andrew Pannell. I'm a partner at Haynes Boone, which is a UK-US international law firm, Dallas, Texas, headquartered. I'm based in London and do a lot of work on the venture capital and private equity side of things, principally on the downstream transactional side, acting both for fund managers as they deploy the capital and also with emerging companies. We do quite a bit of work both in UK, Europe, and also across the pond in the US, and also look at UK, European businesses as they're looking to expand into the US, and advising around that.
Hi all, I'm Saman. I advise high growth tech startups predominantly, and plug in and as a fractional general counsel, so advise across all aspects of their business as they grow. My background is I've worked in some of the fastest growing tech companies globally, probably as they expand internationally, from Go Cardless to Checkout.com, to name a couple. And now I use sort of that experience and expertise to advise smaller companies on their way, with the kind of key advice they need in scaling and sort of juggling legal issues and risks as they come in. So it's great to be here, and hopefully we can all help answer some of your questions.
That is an absolute dream team. Thank you very much to all four of you panelists. Now, I'm sure you've seen some stuff that founders tend to do quite horribly wrong, but also stuff that hopefully might have impressed you and thought, okay, I hope more founders did this. So if we can have a do and a don't in terms of what is important to early stage legalities, that would be great. If we can start with Ishita, please, then Andrew, then Salman, and last but not least, Sharon. And please don't use the same logic for both the do and the don'ts. Take it away.
Thanks, Anton. So do get the right structure for your business, whether it's a sole trader, partnership, or a private limited company. Having the right structure combined with the correct understanding about the tax exposures of your business will help you give a good start. So as a sole trader, you don't need any foundational documents, but if you are a partnership, you'll need a partnership agreement. Or if you're a limited company, then you'll need to have your memorandum and articles of association. Most founders adopt the model articles because they're easy, but sometimes model articles are not fit for purpose, especially if you are a sole director and founder. So get the right documents once you finalize your structure. The don't would be to don't ignore your company's house filings if you've made any changes to your company, because any failure to file the necessary filings can have can attract penalties. And especially if you're preparing to get investor ready, you need to have your compliances in order, as you know, they don't sit well with investors, especially at the due diligence stage. So don't ignore your company's house filings. Thank you.
Thanks, Ishita. Okay, in terms of a do, if you're at the outset of your journey and you have one or more co-founder, one of the things to at least consider up front is what that relationship looks like. And by which I mean, in the worst case, what happens if it breaks down? Something that often will go into early stage documents, whether that's in the investment document or in a founder agreement, is some kind of clawback mechanism in case one of say two founders were to leave the business. It's not really not a popular topic necessarily, or a positive topic to talk about, but in that worst case where someone does decide to move on, the last thing you want is for that exited founder to retain a significant portion of equity. Otherwise the cap table will not look great when it comes to future hires and or external investment. So something to at least consider up front. In terms of don'ts, I guess it's always challenging early stage, but I wouldn't go too cheap. Appreciate that there's a limit to budgets that you can expend on advisors early on, but just be careful about getting some of the key things right. So a little bit like what Ishita mentioned around making sure you've got a good solid structure in place. But for example, where you're looking to set up an ESOP, employee share option plan, or you're looking to structure your investment to take advantage of things like SEIS or EIS, UK tax treatment, there are certain really important, quite basic often, but quite important things not to get wrong there, which may come back to bite you in the future. So some of those basic elements are really important to make sure you don't get wrong up front.
Sorry, I think it was me next.
Yes, it is.
Yeah, so on the do side, and I think in a way following on from both what Andrew and Ishita said, is in terms of foundational things, I think do make sure you own the intellectual property that you're building. So for example, if that's a tech company building software and you're using outsourced providers, make sure you have agreements in place where the IP is assigned to invests in the company you're building. If you're a founder and have been working on something before you set up a company, make sure you transfer the IP into the company. That's especially important once you get to future funding rounds. But the reason behind sort of that, making sure that you own the IP, is that's where your value is, and that's where the brand and the value in the IP will develop over time, and that's what becomes a saleable asset in the future. So worth thinking about and getting right up front, as opposed to sort of firefighting and trying to fix down the line. And then my don't would be probably maybe a bit rare for a lawyer to say, but don't be paralyzed by legal issues throughout. A startup journey does involve risk. It does involve moving forward and growing. So I think the key is not necessarily to get everything 100% right up front, but I think it's focus on the big things. I think it's understand key risks and mitigate them where possible. So I think it's just getting the right advice, like Andrew said, as opposed to being paralyzed by the potential for failure. So yeah, I think they're my do's and my don'ts.
Right. So you're going to be working with a lot of suppliers and other sorts of counterparties, and you'll want to do your due diligence on them. There is a temptation to jump in and find someone who's made an offer of something, but you need to meet a few people and make sure you pick the right ones. Ideally in your own jurisdiction if you can, so that if there's anything that goes wrong later, it's not a headache to try and get hold of these people. So do your due diligence and pick your counterparties quite carefully because they're going to contribute quite materially to your success or failure. My key don't is please don't decide that you don't need a contract. That is an error because at the time when we're involved in our own business negotiations, we very quickly think what could go wrong. We very quickly think we've established all the ground rules. Now, the reason why contracts are a bit longer than, just a few text messages is because in in the past, so many different things have gone wrong. And while we don't want to cover every eventuality, we do want to cover the most important key themes that have kept going wrong over the years and that we as lawyers are able to help you manage as risks. And if you do both those things, you do, which is pick your suppliers carefully and don't ignore the contracting side, then that should set you up in a much more solid way.
Amazing stuff. Thank you very much to all four of you. I think it's time we go on to some questions now. And by the way, whilst I just do a bit of housekeeping and resetting the conversation, I think I might have mentioned earlier, we've had about 290,000 people tune in, but obviously none of that would have happened without you or your fellow panelists. So please do feel free to drop in the chat your LinkedIn URLs in case anyone either now or when they go through the recording wants to get in touch. And maybe just a couple of words about what your strength is or what you focus on in terms of what you can help startups. That would be great. Just a quick reminder, this is Startup Legal Q&A number 11. We're here to help UK startups with whatever questions you may have in terms of your legalities. There are no wrong questions. There's no need to be shy. It's a learning curve for us all. You can ask us today on anything to do from, let's say, incorporation, founder agreement, shareholder rights, IP protection, term sheets, compliance, regulatory requirements, non-disclosure agreements, employment laws, legal documents, and various other templates and contracts. And perhaps you want to talk about disputes you may currently have from co-founders to investors, boards, early stage employees, suppliers, and all that jazz. Please don't be shy. It's a learning curve for us all. All you have to do is drop your question in the chat here on Microsoft Teams, because unfortunately, those of you who are on the live streams, whether you're on LinkedIn, YouTube, Facebook, or Instagram, we're unable to monitor your questions there live. So you'll have to join us here. Quickest way to do that is to go onto our website, startuptoscaleup.club. Again, the website, it's startuptoscaleup.club. You scroll down a little bit, you'll find Startup Legal Q&A number 11. Click join. Quick registration on Luma. There you'll see today's link, which is an audio only link, and it means you can tune in from anywhere via any platform or device. Again, once you're here, then simply drop your question in the chat. We'll give you the mic, introduce yourself, far away with your question. Now, if your questions today are not on the legal side of things, please save them for the other conversations we run. Mondays it's talent, Tuesdays product and tech, Wednesdays growth, Thursdays fundraising, second Friday of each month it's UK startup law, and third Friday of each month it's UK startup finances. That all from 12 to 1 p.m. UK time. That all available on our website, startuptoscaleup.club. And actually, when you're on that site, you may also want to join our WhatsApp community. We've got some amazing groups of various topics where you can connect with founders, investors, other operators, our lawyers, our finance people, and of course the panelists here that are second to none. So without further ado, first question, I'll put that in the chat, but I'll read it out loud for the live streams. This is from a NedTech startup in Grimsby, Lincolnshire. Grimsby, Lincolnshire, lovely. The problem they're currently going through is that a corporate venture capital firm keeps changing the terms after initial commitment. So she then says, our EdTech startup in Grimsby, Lincolnshire had a term sheet in place with a corporate venture capital firm that promised funding. However, after stringing us along for several months, they have now proposed different terms that are less favourable to us. Can we refuse these new terms and claim breach of contract, or are we bound by the original deal despite that change in approach? I don't know why, but either we're getting way too many, well, not too many, but quite a few questions that are similar, or we've actually gone through this before. I'm not sure. Nevertheless, we can start with Andrew, please, then Simon, then Sharon, and last but not least, Ishita. If we can take only about a minute each, that would be great, please, Steve.
Thanks, Anton. Yeah, okay, no, I just read or considered that. For the term sheet, I'm assuming this term sheet was signed at least at a minimum and set out those key terms. As you may be aware, typically term sheets don't tend to be legally binding documents, so they're more just statements of intent, subject to certain sort of key provisions around things like maybe cost, confidentiality, exclusivity. So my gut instinct, I'm afraid, is that given the non-binding nature of those terms, and they'll be subject to things like due diligence, etc., and negotiation of definitive documents, it's going to be difficult to try and enforce on those terms, notwithstanding the fact that the relevant venture capital firm appears to have changed the goalposts a little. So I think that's my sort of immediate reaction to that. I think you can still look to try and go back to them from a sort of good faith commercial perspective and be reasonably robust around understanding the rationale for why they're changing those terms. And of course, from a commercial perspective, if you have other funders potentially available, you can also use that as leverage in order to bring them back into line. The only other thing just to keep in mind is, to the extent that the term sheet contains any binding terms around things like costs or breakup costs, just to be aware of those and make sure that if this investment does terminate, that they don't try and push any of their costs onto you as a business.
Yeah, I think Andrew's. Sorry, Anton. Yeah, I think Andrew's covered it well. I think there's two things I would add, which aren't necessarily legal things, but I mean, normally, as Andrew said, in good faith, things in a term sheet are kind of followed through. So it might be worth drilling into why they're changing the terms. They may feel that something that you've disclosed subsequently has changed, moved the goalpost or something like that. So it's good to understand that. And then I think the second thing to think about is, obviously, even if there's no legal claim, like if you tried to force them into funding or something like that, you've got a long-term relationship with these investors, and ultimately they've got an interest in your business and doing well. So if there's misalignment from the start, you might see this as a kind of lucky escape from something that might have actually been quite a painful relationship longer term. So yeah, if there are alternatives to find investment, that might be a good approach anyway.
Thank you. So it's Sharon and then Ishita, please. Ladies, are you audible?
Yes, thank you. I think keeping in mind what Andrew already said about breakup costs, you are therefore also free to consider other avenues. So while it would be extremely beneficial to also follow someone's advice and find out what it was that made them change their offer, with that further information, you're probably in a better position to also consider other prospective investors now. So having your own freedom, you might think that this might not be the best partner for you because of this changing of the goalposts. And that's the vibe I'm getting also. So while it's nice to have, an offer on the table, the fact that you have an offer probably means that you could get another. So important to consider your options and whether, they've shown their kind of true colors, or whether there's something that you might need to work on that they've identified And a bit like, painting a room in your house before putting it on the market, you might wish to just address that issue so that you can perhaps get a better deal.
I think Andrew, Saman, and Sharon have covered it all. The only point I'll touch upon is where you've asked, can we refuse these terms and claim breach of contract? To which I'll say that you can potentially look for other investors. The way I would approach it is I would at least have a chat with them to understand what went wrong and why there has been a change in the terms, or why they're offering different terms, as Saman has suggested and Andrew suggested. But I wouldn't suggest suing them or going down the litigation route, because that will entail costs again. And you're a startup, you want to kind of devote your time and energy into growing your business and scaling it, rather than getting into a litigation loop. So yeah, that would be my suggestion. Get an understanding of what went wrong and maybe move on from there. But my advice or my suggestion would be, don't go down the litigation route.
That is amazing. Thank you very much to all four of you. Really appreciate that. Right, yeah, we've got 33 minutes to go, so time to go to another question. I've put that in the chat, but I'll read it out loud for the live streams. Rightio, so this is a design and build software development startup based in Wakefield, West Yorkshire. Wow, this is quite a question. As a co-founder of a software development startup, I'm considering selling a portion of my shares to a private investor due to significant personal financial pressures. My fellow co-founders have expressed strong objections, citing concerns over the potential dilution of control and the impact on decision-making within the company. I need to understand the legal mechanisms available to them that may allow them to block my sale, especially in light of our shareholder agreement. Specifically, do they have any veto power over the transfer of shares, or are there specific clauses that grant them the right of first refusal or tag-along rights? Additionally, how can we mitigate the potential fallout from the situation to preserve our working relationship and the company's long-term goals? Assumption is the mother of all wrongdoings, but I'm assuming here, since you've mentioned these things, and I'm hoping you've read the bleeding contract, if you had any, that you didn't sort of instigate, or you didn't specify there any of these things that you've mentioned in terms of veto power, tag along, and first refusal. That's only an assumption, but it would, oh God, it would have been nice if you were here so that we could double check. But let's, if you don't mind, panel, let's just go with assumption that those provisions are not in the contract, hence why this co-founder is asking these questions. So if we can start with Salman, please, then Sharon, then Ishita, and last but not least, Andrew. If we can take about a minute each, please do. And by the way, if you don't feel you've got something to add, it's totally fine to just move on to the next one.
Yeah, I'll go quickly because I'm sure Andrew and maybe others have more of a view on this. But I would say normally there are restrictions around share transfers in the investor agreement, or potentially even in the articles, depending what the articles say. So, I think it's known that private shares or shares in private companies are relatively illiquid. So it's likely they do have some control, especially again depending on where the majority ownership sits. If you own the majority of the shares, maybe you have more control. But I think it's a key question is what's in the documents, to be honest here. So I would say you can't be definitive about it, but it's worth checking the documents, getting some legal advice on the documents to look at what can or can't be done. I think to take it a step back, obviously, if you're facing deep financial pressures and you get on well with your co-founders, maybe there's a way of trying to release some capital for you to resolve some of those issues if you do want to continue the long-term relationship. But yeah, otherwise, I'll hand over to the others to add their thoughts.
Right. Saman has definitely summed up some of the key points. Without looking at the contract, it's hard to say what your particular circumstance is. So let's go to the relationship side of it and say, what can you do if you were to want to go ahead and if the contract allowed it? Perhaps you could consider their meeting the potential investor and being comfortable, because they might need to make sure that investor doesn't have the same rights that you as a co-founder have. Do you know what I mean? So while they might potentially be come around to the idea of an outside investor, the question really would be, what say would that outside investor have in your business? So it would, that is possibly a very important factor, rather than, well, somebody just takes your place. They're not going to do what you do, will they? So I think it is a complex handling of what it is you're giving away that will really matter. And on the relationship side, going back to Saman's suggestion, which was to consider whether there may be an alternative way of easing your financial pressures, because you're also diluting your own stake in the business, are you not? And is that perhaps not desirable in the long term? It's also something to consider.
Yeah, I think Saman and Sharon have kind of explained the main points. My view here is that you need to, like you mentioned, you're asking whether all these rights, would apply. So I'm guessing there is no shareholders agreement or co-founder agreement in place, because if it were, you would be aware of these rights. So first point is, in the absence of any agreement, check your articles of association. The board can have the ability to refuse a transfer if it doesn't seem, the transferee fit for the company. So there could be something in your articles if the company has adopted amended articles, or even sometimes in model articles, you can see that language. So do check your articles of association. The other point would be to, whilst you want to, transfer your shares in order to get a financial incentive to kind of, support you financially, you could consider entering into an employment role with a company where you get paid a fixed salary. You can change, your ownership structure, in the sense, if you want to, like Sharon has mentioned, you can have different rights. So right now, I'm not sure how much stake you own in the company. So if you have a considerable percentage, then it may be worth restructuring, in the sense, maybe transfer a portion of your shares to the investor, or kind of offer them different rights, a different class of shares, and hold an employment or a contractor relationship with a company where you get paid fixed salary for your services, because you're a co-founder, so I'm guessing you have a specific role in the company. So yeah, there these things you should consider and speak to your co-founders as well as the investors, and I'm sure you can arrive at a solution. You don't necessarily have to fall out. Yeah, so in the interest of maintaining a working relationship as well as preserving some of your equity, maybe you don't have to give away all of your stake and control. So think through this carefully. That would be my suggestion. Thank you.
Thanks all. I think my fellow panelists have covered most, if not all, the areas, to be honest. So I don't want to rehash what's already been said. I guess the first takeaway is, as mentioned, really important to actually have a look at the actual documents. So there'll be the articles of association, whatever form they take, which may or may not contain restrictions. And then I think you do reference a shareholders agreement potentially, so maybe then what is a shareholders agreement in place, but that is your starting point. And just in terms of the basic restrictions that may apply, there may be a right of first refusal on any transfers of shares. So that's the first point to check, and whether or not there are any exceptions to that right of first refusal, for example, a permitted transfer. And sometimes, as an example, you can deem a permitted transfer by way of maybe a board approval plus an investor majority consent, depends on the construct of the contract. But that's one thing to consider, whether or not you're actually banned by that ROFA. There's also a concept of co-sale, which is a restriction often placed on founders in the context of a venture-backed business, whereby if a founder is looking to sell a portion of their equity, then again, unless it's a permitted transfer, it would allow investors to also sell down a portion of their equity. So that's another restriction that sometimes applies. And then the final main restriction, just to check, is there any overarching absolute lockup on transfers of shares by founders, which is sometimes placed either again by say a lead investor in an externally funded business, or potentially into founder, because your fellow co-founders want to have some control for this type of situation. So those are the three key areas to consider in the contracts, and happy to take a look separately if you wish. Just thoughts in terms of the overall process quickly. I mean, whilst there may be a little concern, your fellow co-founders, around dilution, etc., that's sort of understood. That being said, like any good startup, which is often cash-strapped and bootstrapped, it's quite normal for founders to be thinking about liquidity, or at least partial liquidity. So it's a perfectly fair thing to be considering. So hopefully having a sensible conversation with them, or following on from that, you can try and get somewhere. And the points around the investor profile, I think, are very on point as well, that Sharon and Salman mentioned as well. The other thing you could consider, if they're genuinely concerned and those co-founders have the financial firepower themselves, is whether you could sell back to those co-founders. That might be another route, at least to consider. And I think that's about it from me. Thanks.
Thank you very much to all four of you. Really appreciate that. We are now going to go into question 3, if you don't mind. I will read it out loud for the live streams, but the team here in the panel can read it and refer to it in the chat. So this is a cybersecurity startup in Haverhill, in Suffolk. Okay, long-lost associate threatens lawsuit. Okay, that's an interesting one. That happens way more often than we'd like. Most, in all the years that I've been, over 20 years that I've been in and around the startup ecosystem, most founders tend to worry about stuff going wrong with investors, but guess what? It's mostly with co-founders and other people. So, nevertheless, I'll read out the question. So, long lost associate claims the idea for the cybersecurity product was theirs. Question: our cybersecurity startup in Suffolk has been developing a new threat detection system, and a long lost associate whom we haven't heard from in years is now claiming that the idea is theirs and threatening to sue. The product concept has evolved significantly since our initial discussions. We have documentation and emails proving our ownership. What legal protections do we have to defend our position, and what steps should we take to resolve this potential claim without escalating into a lawsuit? Now, he says associate, so I'm not sure whether to assume they were somehow involved in this business at all, or maybe it was just conversations I don't know, like working for some other company together. And so it sounds a bit wishy-washy, but let's hear it from the legal experts. Let's start with Sharon, then Ishita, then Andrew, and then Salman, please. If we can take about a minute each. And again, same applies. If it's not really your bag, don't worry about passing it on. Sharon?
Yes. So on the plus side, an idea in itself can't be protected. So it's very much about what exactly their involvement was. Because anyone can copy an idea. I mean, I can go out and do things that have been done before, but I'd have to do it in my way. I can't kind of copy the code because that would be a breach of copyright. So if you're brainstorming or chatting over a drink and someone says, wouldn't it be great to have an online bookstore? And then later somebody starts Amazon. Well, that's not going to, you can start another online bookstore. That's no problem. So really, it's down to what their contribution actually was. And if they actually had a material contribution that you know and would like to acknowledge, then perhaps you can offer them something in exchange for their actual contribution. And if you feel they didn't have much of a contribution at all, and that contribution in a commercial way, it could simply have been an idea, and you might think, yeah, actually we'd like to recognize that. But if they own any of the intellectual property in actual fact, then you probably might like to make some kind of offer. But if it's nothing like that, then it's not perhaps in danger of escalating into a lawsuit. The best way to usually prevent a lawsuit is to have a conversation, but that may only work if the other side is being reasonable in the first place. So preventing a lawsuit is as easy as the person on the other side of the table wants it to be. So with that, I shall hand to my colleague.
Thanks, Sharon. Yeah, taking on from Sharon, basically, and to reiterate that an idea or a concept is not itself an intellectual property, right? So where you've mentioned is a long lost associate, so I'm wondering what their capacity was and what capacity were they engaged with you at that time, whether it was under a contractor arrangement or an employment arrangement, or whether there was an NDA in place, because generally these documents have clauses about assignment of any intellectual property. So do check what documents you had in place, because you say that you have documentation and emails proving your ownership. So if you can establish that they have in essence assigned their IP whilst they were engaged with you, then you can establish your ownership in that manner. And if negotiations don't work, then at least you have your legal position right, where you can demonstrate that the IP was assigned, or a non-disclosure or an assignment deed was in place, which will strengthen your position legally. So if at all they were to pursue a legal action, you will have a good actionable defense as well. Yeah, that's it. Thank you.
Thanks, Vic. I'll defer to others, better specialist IP knowledge, including Salmon and Co. But just two things I would add is, one, just reading off the face of the question itself, it feels to me like this is a bit of a try-on, because it's long lost some time ago, and yeah, it's fair to consider in what capacity. But I would have thought that if a discussion is not tenable because it doesn't sound like they are being particularly sensible in terms of their approach, if you need to, a firmly worded email or letter back refuting any alleged claims on their part may well just do the trick, because I doubt if they're an individual, they're going to want to start expending significant cost and time trying to actually bring a claim. So it feels a bit of a triumph as far as I'm concerned. Of course, if you do write any communications, it should always be done in a professional and calm, measured manner. but I would say that that's probably the most practical way of trying to knock it on its head, and then hopefully leave it at that. The only other point I would just keep in mind, to the extent there is any genuine risk or legs in that claim, is just to consider exactly what you do have in terms of concrete ownership, and to